In 2003, the Lagos State House of Assembly passed the Hotel Licensing Law, which was amended in 2010 and gazetted on July 20, 2010. The law made provisions for the licensing of hotels and further empowers Lagos State government to make laws to regulate, standardize, and grade tourism operations. Furtherance to this, the Lagos State House of Assembly enacted the Hotel Occupancy and Restaurant Consumption Law.
The law that was enacted by the Lagos State Assembly in 2010 falls within the confines of its constitutional powers. We are talking about strict constitutional compliance.
The federal government, before the Supreme Court, challenged the right of the Lagos State government to make laws on tourism, specifically where the National Assembly had already legislated on the same issue through the Nigerian Tourism Development Corporation (Ntdc) Act. But the Apex Court dismissed the federal government suit and delivered its judgment in favor of Lagos State. It was the view of the court that the Ntdc Act went beyond its powers, as stated in the exclusive legislative list of the Constitution, which is to regulate tourist traffic. Now, there is a bill pending before the National Assembly, known as the Nigeria Tourism Development Authority (NTDA) Act. Section 15C of the bill seeks to regulate hotels and tourism activities, which conflicts with the Lagos State's Hotel Licensing Law. A public hearing on the bill was held on August 17 under the auspices of the Senate Committee on Culture and Tourism, chaired by Senator Matthew Orogede. This raises the question of whether the National Assembly is empowered to make a law on an issue already determined by the Supreme Court.
What is playing out now is the fact that the National Assembly is not being properly advised. Because if they are being properly advised, amending the Nigerian Tourism Development Corporation Act would still not give them the leverage, the constitutional color and muzzle to override the proclamations and the laws made by the Lagos State government in 2010. It is an issue that falls within the residual powers.
If the lease is under residual, is principally within the competency of the state, it will be unconstitutional for the National Assembly to intrude to the areas specially meant for the state. That is why we have the Constitution. It stipulates the areas in which every organs of the polity can operate.
If this bill is eventually passed into law, what implications will it have?
Their job is to make laws, and the interpretation that must be given to such laws is that when there is a conflict between an enactment, a law from the National Assembly and that of a state assembly, of course, if the laws deal with the same issue, of course, the laws from the National Assembly will override under that principle of covering the field.
The National Assembly, in their own constitutional duty, wanted to expand the scope of the law by promulgating another law covering wider areas. Whatever the provision of the state and the federal legislature, that of the federal legislature will override that of the state. And the judgment of the Supreme Court will have no effect on the existing new law.
Nigerians await how far the National Assembly will go with this issue and whether the judiciary will intervene at any point. Seyifunmi Olatide, LTV News.